Welcome to the overview of the Digital Personal Data Protection Act 2023. This landmark legislation passed on 11th August 2023 aims to safeguard individual privacy and regulate personal data processing in the digital age. This chapter explores the Act's purpose in addressing rising data breaches, aligning with global standards like GDPR, balancing innovation with privacy. Background and purpose of the DPDP Act 2023. The Digital Personal Data Protection 2023 DPDP Act is a critical piece of legislation introduced by the Government of India to address growing concerns over privacy and the protection of personal data in an increasingly digital world. The Act was passed on 11th August 2023 to provide a legal framework that regulates the collection, storage, processing, and sharing of personal data. Key drivers for the DPDP Act: 1. Rising data breaches and privacy concerns. With the exponential increase in the amount of personal data being collected digitally, incidents of data breaches and unauthorized access have significantly risen. This surge has led to concerns over the misuse of personal data, identity theft, and violation of privacy rights, making data protection a top priority. 2. International influence. The need for a comprehensive data protection framework in India was further propelled by the influence of international data protection laws such as the General Data Protection Regulation, GDPR, in the EU. India recognized the necessity to align its data protection laws with global standards to foster trust in its digital economy and enhance its competitiveness on the global stage. Number 3. Balancing innovation and privacy. The DPDP Act aims to strike a balance between ensuring robust data protection for individuals and allowing businesses to freely process data to drive innovation. Sectors like e-commerce, fintech, healthcare, and artificial intelligence, AI, depend on vast amounts of personal data to fuel their operations and growth. Purpose of the DPDP Act: to safeguard personal data. The primary goal of the DPDP Act is to protect the personal data of Indian citizens, ensuring that their data is handled responsibly and in compliance with privacy standards. To ensure accountability of data fiduciaries, the Act outlines the responsibilities of data fiduciaries, entities that collect and process personal data, and holds them accountable for maintaining data security and abiding by the privacy laws. To regulate data processing by foreign entities, the DPDP Act extends its provisions to foreign entities that process the personal data of Indian citizens. This ensures that businesses, regardless of their geographic location, adhere to the same data protection rules when handling Indian citizens' personal data. Relevant sections. Section 2 defines essential terms such as personal data, data fiduciary, and data processor, which are key to understanding the scope and obligations of the DPDP Act. Section 3 defines the territorial applicability of the Act, specifying that it applies to the processing of personal data within India, regardless of where the data fiduciary is located. Key features and provisions of the DPDP Act 2023. The DPDP Act lays down a clear and enforceable framework for data processing, aimed at protecting the privacy of individuals and ensuring accountability of data controllers. Key provisions. 1. Consent-driven data processing, Section 6. Personal data can only be processed if the data principal, individual, provides free, specific, informed, and unambiguous consent. Example: when signing up for an online shopping platform, users must be informed about what personal data is being collected, such as name, email, address, and how it will be used. The user must explicitly consent to this data collection. 2. Rights of data principals, Sections 11-13. Right to access. Data principals have the right to request a summary of their personal data held by a data fiduciary. Right to correction, completion, and erasure. Data principals can request corrections, updates, or deletion of their data if it is inaccurate, incomplete, or no longer necessary for the specified purpose. Right to withdrawal of consent. Data principals can withdraw consent at any time, and the processing of their data must cease unless required by law. Example: if an individual withdraws consent for marketing purposes, the company must stop processing that data for targeted advertising. 3. Accountability of data fiduciaries, Section 8. Data fiduciaries are held responsible for complying with the provisions of the DPDP Act, including ensuring the security of personal data, preventing data breaches, and conducting audits. Example: a bank, as a data fiduciary, is required to ensure that customer data is encrypted and stored securely to prevent unauthorized access. 4. Data Protection Officer (DPO). Section 10. Significant data fiduciaries must appoint a data protection officer who will oversee compliance with the Act, handle data security issues, and serve as a liaison with regulatory bodies. Example: a multinational technology company that processes vast amounts of sensitive data will need a DPO to ensure compliance with the DPDP Act's requirements. 5. Data Protection Board of India, Section 18. The Data Protection Board of India is an independent body responsible for overseeing compliance, investigating complaints regarding data breaches, and enforcing penalties. Example: if a company fails to notify data subjects about a breach, the Data Protection Board can investigate and take action, including imposing fines. Number 6. Penalties and Enforcement, Section 33. The Act mandates penalties for non-compliance, ranging from fines for minor violations to significant penalties in the event of major breaches. Penalties can be up to 250 crore, depending on the severity of the violation. Example: if a company fails to obtain consent for processing personal data, it could face substantial fines as prescribed by the Act. Conclusion and key takeaways. The Digital Personal Data Protection Act 2023 represents a significant step in securing the privacy of individuals in India and regulating the growing digital economy. It provides clear guidelines for how personal data must be handled by organizations and empowers individuals with rights to control their data. Key takeaways. Consent. Data processing must always be consent-driven, with individuals retaining control over their personal data at all stages. Rights of data principals. Data principals have the right to access, correct, update, and delete their personal data, and they can withdraw consent at any time. Accountability. Data fiduciaries are accountable for safeguarding personal data, complying with regulations, and ensuring security measures are in place. Regulation and penalties. Non-compliance with the Act can result in hefty fines and penalties, ensuring robust enforcement. The DPDP Act is aligned with global data protection standards, setting India on the path toward a safer and more secure digital economy, while protecting the privacy rights of its citizens. In the next chapter, we will explore Chapter 2 of the DPDP Act, focusing on the scope and application of the Act, and understanding the obligations and territorial jurisdiction it covers. This chapter has introduced the core principles and provisions of the DPDP Act and laid the groundwork for deeper discussions on implementation and compliance across various sectors. Thank you for joining this session. In the next lesson, we will explore the scope and application of the DPDP Act, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.